Hello everyone, welcome to Kakatiya IAS. So now we are going to discuss today's current affairs analysis. First of all, we are going to discuss about the global burden of cancer. Health related issues. So now coming to the context, the International Agency for Research on Cancer, IARC, the Cancer Division of the World Health Organization, WHO, presented the most recent estimates of the global burden of cancer in 2022 ahead of World Cancer Day on February 4th. So, according to the IARC estimates, there is an urgent need to address cancer disparities globally, given the growing burden of cancer and the disproportionate impact on marginalized people. So, which are the WHO's key takeaways for the global burden of cancer in 2022? So, now coming to these answer, worldwide burden. So, 20 million of new instances of cancer and 9.7 million deaths from the disease are predicted for 2022. So, 53.5 million people were predicted to still be alive 5 years after receiving a cancer diagnosis. Cancer affects 1 in 5 persons at same point in their lives. So these are the typical types of cancers. In 2022, the 10 most common kinds of cancers, 10 most common kinds of cancer accounted for approximately 2/3 of the all new cases and deaths worldwide. Lung cancer accounted for 2.5 million new cases globally, 12.4% of all new cases, making it the most common cancer. With 2.3 million instances or 11.6% of all cases, female breast cancer came in second, ahead of colorectal, prostate and stomach cancers. So these are all the types of cancers. Next, coming to the principal causes of death. The most common cause of cancer-related fatalities, 18.7% of all cancer-related deaths was lung cancer. 1.8 million deaths, which was followed by the colorectal cancer and liver cancer, breast cancer and stomach cancer. The resurgence of lung cancer as the most frequent malignancy is probably connected to Asia's long-term tobacco consumption. So now going to the cancer disparities, the incidence of cancer has varied dramatically depending on human development. This applies especially to breast cancer. In nations with extremely high human development indexes, 1 in 12 women may receive a breast cancer diagnosis during their lifetime. So 1 in 71 will pass away from the disease. In comparison, 1 in 48 women will pass away from breast cancer in nations with a low HDI, even though only 1 in 27 women will receive a diagnosis of the disease during their lifetime. Compared to women in high HDI nations, women in lower HDI countries had a 50% lower chance of receiving a breast cancer diagnosis. However, because of delayed diagnosis and insufficient access, high quality treatment, these women also faced a much higher risk of dying from the disease. So now coming to the estimated rise in burden, it is anticipated that there would be over 35 million new cases of cancer in 2050, a 77% increase over the projected 20 million cases in 2022. The fast increasing incidence of cancer worldwide is a result of changes in risk factor, exposure, many of which are linked to socio-economic development as well as population expansion and aging. The rising rate of cancer is mostly caused by alcohol, tobacco use and obesity. Air pollution is still a major contributor to environmental risk factors. High HDI nations are anticipated to bear the large absolute rise in incidence with an extra 4.8 million new cases expected in 2050 compared with estimates of 2022. So now coming for the request for action, major expenditures are desperately needed to address the disparities in cancer outcomes that exist around the world and guarantee that everyone, regardless of geography, or socioeconomic background has access to reasonably priced high quality cancer care. So let's discuss what are the most important results concerning India. In 2022, India recorded 14,13,316 new cases with a greater percentage of female patients. Female patients 69 lakhs 1,178 women versus 72 lakhs 2,138 men. With 19 lakhs 2020 new cases, breast cancer had the largest percentage in the nation, making up almost 26% of cases in women and 13.6% of all patients. Cervix and uterine, lung, esophageal, lip and oral cavity 14 lakhs 3,759 new cases, 10.2%, and breast cancer were the next most common cancers in India. According to a recent WHO World Health Organization study evaluating the cancer burden in Asia, which was published in the Lancet Regional Health, India was responsible for 28.1% of new instances of lip and oral cavity cancer, 32.9% of global deaths from this disease in 2019. So, this was due to the fact that South Asian nations like Bangladesh, India and Nepal heavily consume smokeless tobaccos, products including kaini, gutka, betel quid and pan masala. So, SMT accounts for half of the cases of oral cancer globally. According to the Lancet Global Health 2023, 23% of cervical cancer related fatalities worldwide happened in India. The 5-year survival rate of cervical cancer in India was 51.7%. That being said, India's survival rate is lower than that of wealthy nations like the US. So coming to the next topic, Delimitation Commission related to the government policies and interventions. So now coming to the context, after 2026, the first census will serve as the basis of delineating the constituencies for the Lok Sabha and the state legislative assemblies. Initially delayed by the COVID-19 epidemic and by the central government delays, the 2021 census was rescheduled. So now we will know what is the delimitation. Delimitation is the process of allocating each state's territorial constituency borders and number of seats for the Lok Sabha and legislative legislatures. So it also entails figuring out which seats in these houses should be set aside for scheduled castes SCs and scheduled tribes STs. So the Delimitation Commission, which was established by the parliamentary legislation, oversees this delimitation process. Under the Acts of 1952, 1962, 1972 and 2002, delimitation commissions were established 4 times. Those are 1952, 1963, 1973 and 2002. So in 1950 to 1951, the President conducted the first delimitation process with assistance from the Election Commission. Passed based on the results of the 1971 census, the latest delimitation process that altered the Lok Sabha state by state makeup was finished in 1976. So as per the Indian Constitution, the distribution of seats in Lok Sabha must take into the account of the population of each state with the aim of achieving a nearly equal ratio of seats to the population in every state. The goal is to guarantee that every voter, regardless of state, has approximately the same weight when casting a ballot. But because of this clause, states that showed less interest in population control wind up with more seats in parliament. In order to prevent such outcomes, the 42nd Amendment Act of 1976 suspended at the 1971 level the distribution of Lok Sabha seats among the states and partition of each state into territorial constituencies effective until the year 2000. So, the 84th Amendment Act of 2001 gave the government the authority to redraw and rationalize state territorial constituencies based on the population estimates from 1991 census. So, the next 87th Amendment Act of 2003 mandated the constituencies can be drawn using the result of 2001 census rather than the 1991 census. It is possible to accomplish this without changing the number of Lok Sabha seats assigned to each state though. So now coming to the articles of constitution, after each census, the parliament passes a delimitation act in accordance with the article 82. Following each census, states are also divided into territorial constituencies in accordance with Delimitation Act under Article 170. So let's see what role does delimitation play. By modifying the number of seats in accordance with changes in the population, delimitation guarantees equitable representation in Lok Sabha and state legislative assemblies. Maintaining the democratic idea of one citizen, one vote and one value depends on this. So delimitation is the process of redrawing the borders of geographical constituencies in order to ensure that seats are distributed fairly among various regions while taking population movements into account. This assists in avoiding the under or over representation on particular regions. In compliance with constitutional provisions, delimitation determines the distribution of reserved seats for scheduled castes and scheduled tribes, those are SCs and STs, guaranteeing sufficient political representation for marginalized populations. Delimitation affects federal principles by affecting how states divide their political authority. Maintaining unity among varied regions necessitates striking a balance between federal considerations and population-based representation. So now let's see methods of population control. In the past, population control measures were intended to be encouraged by the seat freezing based on the 1971 census. But in the light of shifting demographics, the upcoming delimitation process begs concerns about the efficacy and ramifications of this approach. So, what are the delimitation related concerns? Populations as a determining factor in the representation gap in the Lok Sabha between the northern and southern regions of India. The delimitation based only on population ignores the advancements in population control made by the southern states could result in differences in the federal government's organization. The southern states provide 35% of nation's GDP, even though they only make up 18% of the nation's total population. Due to the faster rate of population expansion, the northern states, which did not prioritize population control, are anticipated to gain throughout the delimitation process. So there were worries that the southern states might lose funding and parliamentary representation after the 15th Finance Commission based its recommendation on the results of 2011 census. Previously, recommendations to states about financing and tax devolution were based on the results of the 1971 census. So what are the impacting SCs and STs reservations? In addition to costing southern states seats, the planned seat reallocation and delimitation could provide political parties with a strong hold in the north more influence. This might cause the balance of power to move from south to north. So the division of seats set aside in each state under Article 330 and 332 for scheduled castes and scheduled tribes would also impacted by the exercise. So coming to the next topic, Jubilee year of the Supreme Court, judiciary related issues. So now coming to the context, the Supreme Court of India celebrated its 75th anniversary and Diamond Jubilee recently in the Supreme Court Auditorium in Delhi. Additionally, the Indian Constitution's 75th anniversary falls on the same day. Several citizen-centric information and technology projects aiming at improving judicial accessibility and transparency were launched during the occasion. So, which aspects of the event stand out the most? The occasion included the debate of several digital projects such as the Digital Supreme Court Reports, DZSCR, Digital Courts 2.0, and redesigned SC website. The goal of the Digital Supreme Court Reports project is to promote accessibility and transparency by offering free electronic access to Supreme Court rulings from 1950 onward. A major advancement in the efficiency of record keeping and judicial procedures is represented by Digital Courts 2.0, which use AI, artificial intelligence, to transcribe court sessions in real time. The redesigned Supreme Court website provides easy access to judicial information with a user-friendly interface and is available in both languages Hindi and English. So, the emphasis was on improving the accessibility of justice, especially in distant places, and on extending the authority of the Supreme Court. The extension of the Supreme Court building complex and other investments in physical infrastructure were emphasized as essential measures to improve judicial efficiency. So, let's see what are the crucial details concerning the Supreme Court. So, how did the establishment done? The Supreme Court was established on January 28, 1950, 2 days after the India became a sovereign democratic republic. So, it took over from the Federal Court of India, which was founded in 1935 by the Government of India Act. The British Privy Council was superseded by the Supreme Court, which now has more jurisdiction than its predecessor because it is the highest court of appeals. So now come to the constitutional provisions. Part 5 of the Constitution, Article 124 to 147 addresses the Supreme Court's structure, autonomy, authority and the other matters. They can also be regulated by the Parliament. So who are all the present members? The present members of the President of India appoints 34 justices, including the Chief Justice of India, to the Supreme Court of India. So, a Supreme Court with a Chief Justice and 7 judges was envisioned in the 1950 original Constitution, which left up in a Parliament to raise the number. Chief Justice of India appoints are made by the President following discussions with a subset of Supreme Court and High Court justices. So, the Chief Justice and the extra justice from the Supreme Court and High Court advise the President before appointing the further judges. Any judge appointed other than the Chief Justice of India must first consult with the Chief Justice of India. So, what are all the qualifications that are for appointment? An individual must be an Indian citizen in order to be eligible to serve as Supreme Court judge. They also need to acknowledge by the President as a distinguished jurist and have served as a judge in a high court for a minimum of 5 consecutive years or as an advocate in an high court for a minimum of 10 consecutive years. Nonetheless, there is no minimum age requirement for nomination to the Supreme Court as a judge specified by the Constitution. When they turn 65 years, they retire. Judges are not allowed to practice in any Indian court or before any authority once they retire. So, what is the judge removal? How can it remove? So, the President may issue an order to remove a Supreme Court judge from the position. Only after receiving a presentation from Parliament in the same session regarding the removal may the President issue an order for its removal. On the basis of demonstrated misbehavior or incapacity, the speech must receive the endorsement of a special majority of each House of Parliament, which is equivalent to a majority vote of 2/3 of the members present and voting. Language of the proceedings and regulation. So, what are all the languages? Only English is used for Supreme Court proceedings. So the Supreme Court's practice and procedure are governed by the Supreme Court rules 1966 and 2013, which are created under Article 145 for the Constitution. So Supreme Court independence, fixed service conditions. Unless there is a sudden financial emergency, Parliament sets the salaries, allowances, and other perks for judges, guaranteeing constituency in the service conditions. So, in order to maintain financial independence, salaries, benefits, and administrative expenses are charged against the consolidated fund, rendering them non votable by Parliament. So, what is the behavior immunity? With the exception of impeachment procedures, Parliament and state legislatures are not permitted to debate the behavior of judges. Article 121. So, power to punish contempt. Article 129 of the Constitution grants the Supreme Court to power to punish contempt in order to uphold its authorities and rulings. Autonomy in staff appointment. So, the Chief Justice of India is unrestricted by the executive branch in selecting Supreme Court employees and determining their terms of employment. So, what is the protection of jurisdiction? Parliamentary may increase but not decrease the Supreme Court's authority. Executive influence in judicial matters to be eliminated. The Constitution's Article 50 requires the judiciary and executive branches to be kept apart in public services. So, what is the relevance of High Court? Guardian of the Constitution. By issuing writs pursuant to Article 32, the Supreme Court upholds the Constitution, guaranteeing its supremacy and defending fundamental rights, maintaining the rule of law. By using the judicial review power, it serves as the last arbiter in legal disputes, interpreting the law and making sure it is applied fairly. So, what are the human rights and social justice? The court is essential to advancing social justice, defending underprivileged groups, and respecting these rights. Monitoring executive overreach. This ensures that the executive branch operates within the bounds of the law by acting as a check on it. The way ahead, dividing the Supreme Court. The 10th Law Commission of India suggested creating the Constitutional Division and the Legal Division as the two separate branches of the Supreme Court. The plan stated the Constitutional Division would consider only cases pertaining the Constitution law. In a similar vein, the 11th Law Commission reaffirmed in 1988 that dividing the Supreme Court could improve justice accessibility and lower legal fees. In order to hear cases involving non-constitutional matters, the 229th Law Commission report of 2009 suggested setting up 4 regional benches in Delhi, Chennai or Hyderabad, Calcutta and Mumbai. So, enhanced judicial sitting. In order to elevate the backlog of unresolved cases, the Malimat Committee recommended raising the Supreme Court's working days to 206 days, reducing vacation time by 21 days. In a similar vein, the 2009 Law Commission suggested in its 230th report that all judicial levels shorten court vacations by 10 to 15 days in order to reduce the backlog of cases. Re-examining the NGAC's establishment. So, the NGAC Act may be revised to include measures guaranteeing its constitutionality and restructured to guarantee the judiciary's continued majority control. Improving diversity by gender in the judiciary. How to improve? So, establishing a set proportion of female judges would encourage the growth of an inclusive legal system in India. Gender parity in the judiciary will be achieved with the nomination of Justice B.V. Nagaratna, who is expected to become India's first female Justice of India in September 2027. So, next, coming to the next topic, personally identifiable information, government policies and interventions. So, now coming to the context, following a cybersecurity research alert to the Computer Emergency Response Team of India, CERT-IN, the Ministry of Corporate Affairs has addressed a significant vulnerability in its web portal. According to reports, the breach exposed over 98 lakh directors of Indian firms' personally identifiable information (PII), including Aadhaar, permanent account numbers, that is PAN card, and voter identities, date of births, phone numbers, communication address. So here the PII stands for personally identifiable information. Any data or information kept on file by a company or organization that might be used to identify a particular person is known as personally identifiable information or PII. Information like Aadhaar, PAN, voter identity, passport, date of birth, phone number, email address, biometric data may be included in this. So, depending on the nation of origin of individual, different PII components apply. So, what are the PII types? Let's see. Direct identifiers and indirect identifiers. So, these are the two categories of PII. So, individually identifiable numbers such as driver's license or passport number are examples of direct identifiers. Usually, one direct identification is sufficient to establish someone's identity. A non-unique indirect identifier is one. They contain more generic personal information like birthplace and race. A person can only be identified by a mix of indirect identifiers, a single cannot. So, certain PI maintains more sensitive information than others. So, private information. It is the private data may be used to identify a specific person, and that even that it is stolen or disclosed might be extremely harmful. Most current data privacy regulations require organizations to protect sensitive personal information (PII) by encrypting it, limiting access, or implementing other cybersecurity measures. Sensitive PII is often not available to the public. So now coming to the non-sensitive personal information, it's private information that if disclosed or taken wouldn't seriously hurt an individual. It could be specific to an individual or not. A social network handle, for instance, would be considered sensitive PII. It may use it to identify a person, but with just the name of the social network account, a bad actor couldn't steal someone's identity. Information like zip code, color, gender, and religion are also included in this. There are not reliable means of identifying a specific person. So, not PII. Information that cannot be used to locate or identify a person on its own is known as non-personally identifiable information or non-PII. Nonetheless, non-PII can be utilized to identify a specific person when combined with other data. Photographic images, particularly of the face or other distinguishing features, place of birth, religion, geographical indications, work details, educational background, and medical records, are the examples of non-PII information. So, what dangers come with the exposure to PII? Theft or identity. First one. Exposure to personally identifiable information PII raises the danger of identity theft, in which thieves utilize stolen personal data to assume identities in order to commit fraud. So, cyber attacks and flaws in digital infrastructure may expose personally identifiable information of citizens. So, next coming to the financial theft. Financial fraud may result from exposed personal information such as credit card numbers or bank account details, etc. So, criminals have the ability to get access to the bank accounts, carry out fraudulent activities, steal money from accounts assigned to the recipients of government assistance programs, or cause financial damage for the victim. So, the infractions of privacy. Exposure of PII may infringe privacy, jeopardizing people's autonomy and secrecy. Unauthorized access to personal data may lead to harassment, stalking, and invasions of privacy for those involved. Attacks using social engineering and phishing. Cyber criminals may utilize PII that has been made public to launch phishing attacks, which deceive victims into divulging more private information or clicking or harmful links. Social engineering attacks like pretexting and impersonation schemes use exposed personally identifiable information to trick people into disclosing private information or allowing unauthorized access. Repercussions of data breach. Data breaches frequently result in PII exposure, which can cause large financial losses, remediation expenses, and reputational harm to the company. Reduced income, a decline in consumer trust, and heightened security from stakeholders and authorities can all be detrimental to an organization. Thank you. So please like, share, and subscribe the video. Subscribe our channel. Thank you.